Good morning.
Morning, Judge.
Can everyone hear me okay? All right, thank
Yes,
you.
we can.
All right, good morning. Today is June 24th, 2026. It is exactly 10 a.m. We are here on the non-complex calendar. We have motions and I believe status conferences. And is there one add-on for a plea? Before we get started, are there any announcements?
Good morning, Your Honor. This is Attorney Andre Smith here from Maya Didell.
Okay, good morning. Just a moment. Are there any additional announcements?
Good morning, Your Honor. Attorney Georgetta Glaves, and it's for Demetrius Jackson, Judge. That is the case that's on for a negotiated plea.
Okay, thank you.
Thank you, Your Honor.
And then Judge, I guess I'll announce too, this is Attorney Chad Trinacosta for
should I have,
I'm sorry.
Tylander Dearmas on the case. And I believe I just sent Riona an email and a chat within the thing. I believe the case will be null pros today. So I just want to confirm that.
Okay, when Ms. Bray comes on, we can confirm that. Was there someone else who was attempting to make an announcement? Okay,
Yeah, to piggyback on Maya.
Judge.
Go ahead.
Mr. DiTardo, if you're attempting to speak, it seems as though you're breaking up. Let's try again. Okay, Attorney Smith.
And actually, Judge, I could probably speak, and I'm sorry to interrupt again, but from Mr. DiTardo, I saw his name on the 9 o'clock calendar, and it was for a Michael Ramirez. This case, he inadvertently filed an entry of appearance, and it's just so happened to be my case. We had already closed that case as a negotiated plea months ago. So I know he's on for like a motion to withdraw his counsel or something like that, and it was on 9. But again, he inadvertently filed it, notified the court, and I had already closed the case anyway. So he should be excused and removed from the case.
So that's position 2 on the motions calendar, and I granted the motion to withdraw yesterday. So that's 25 SC 004346, Michael Ramirez.
Awesome. Yeah, and that case was already closed too.
Okay, all right. So
yeah,
that is a moot point. So
I'm sorry, Judge. Attorney Trinacosta, what do you mean it was closed? It's still showing us open on our end.
Oh, yeah, I believe it's been closed. I'll double check unless this is a different Michael Ramirez.
Let's confirm that before you log off.
Okay.
But I did grant the motion to withdraw. But let's confirm the status as to whether it is open. Attorney Dalton.
Yes, Your Honor. Good morning. Alicia Dalton on behalf of Giselle Woodhouse. I do see that Your Honor granted the motion to withdraw that motion for us to withdraw the motion to suppress. Both my client and I are present. We just wanted to know if we could be excused, or did Your Honor need us to stick around?
No, you may be excused. I do recall granting that, but thank you for joining us today.
And Judge,
Thank you, Your Honor.
I'm sorry, the next court date will be the 1/7 final plea. So that's the next court date.
Thank you.
You're welcome. Thank you.
Attorney Dalton, you are excused.
Okay. Thank you.
Attorney Dalton withdrew the motion to suppress? Is that
yes?
Okay.
Hey, Your Honor, Attorney Andre Smith here again. To finish up my announcement on Maya Didell, we had an open court agreement that the case will be null pros in May. However, it was never filed. So we were here today to make sure that the null pros is going to be signed and filed as we've been waiting since the last court date.
Okay, and I'll get to your case when I go through the calendar. I would like to get those folks, if I've already ruled on their motions, I would like to.
They're gonna be looking for my name. Let me see if I can.
Mr. Sturgis, is it Mr. Sturgis? You need to put your device on mute.
Okay. Attorney Smith, could you send me the basis for the null pros, please?
I mean, we put it on the
record in the chat.
Court. Oh, okay.
We did?
We did. We
put
put it on the record in
chat.
open court in front of Judge Oliver back in May.
Oh, well, that would not have been me, though. Do you know who the DA was?
It was you.
I don't remember being in front of. I was in front of Oliver.
You were.
It
Hello?
was 88 Bray. Judge Oliver was filling in that day for Judge Brooks.
And there was an email chain as well with the court about the no pros.
Okay,
So
still put
it's
the
on.
basis in there.
Your
Or do you have the
microphone is
basis,
on
Ms.
mute.
Moore?
Mr. Sturgis?
No, this is Marquise Berry, and I had to my phone wouldn't let me do it, so I had to log in from my
Okay, but for now, I need you to put your device on mute
Okay.
and
And
I'll
his
get
case
to
has,
your case.
his case should have been null pros already. I remember sending in a null pros for Marquise Berry.
That's closed out.
I checked last night.
Okay.
He's
What position?
16 on pretrial conference.
Okay, and my access to Odyssey is non-existent at the moment. So has that case been null pros?
It has,
Yeah.
Judge.
Yes.
All right, so is there anything further on 16, which is 25 SC 000010 for Marquise Berry?
No, Judge.
Okay. All right, thank you for the confirmation. All right, 16 has been null pros. Before I call the rest of the calendar, Michael DiTardo, were y'all able to sort out whether you were here on the correct case as it relates to the motion to withdraw? Did I not see him?
Yeah, I believe he was on earlier. He made an announcement. I think he had some sort of issue.
Yeah, I thought I saw him as well. Were you able to confirm the status?
I is the case number 25 SC 002531?
No.
It's
Okay,
25.
then
That's not your
okay,
case?
then it's a different Ramirez. No, correct. So I
Okay.
don't know what this one is. It just
All right,
I guess
so-
he's on a couple Ramirez's.
Okay, am I overlooking Mr. DiTardo? I thought I saw him on the Zoom, but I no longer see him.
No, Judge. He's not on.
All right, we'll see if he joins us. And Attorney Cole, I know you had motions as well.
Okay, Your Honor, I sent in, just so we're clear, on number 2, Michael Ramirez, when I went back through the email chain in my office, and also I received an email from Mr. DiTardo, Attorney DiTardo. I've drafted a null pros and I sent that in. So
Okay.
I included you, Ms. Moore, so it's on there. This morning I sent it in,
Okay.
like
so
right before I got
position-
online. So
Thank
that'll
you.
be
So
closed.
position 2, 25 SC 004346, Michael Ramirez is also a null pros. And so if Mr. DiTardo rejoins us, we will notify him at that time. Otherwise, he will receive a copy of the filing. Attorney Cole, I understand that you have motions as well, but I will take that up after I go through the rest of the calendar.
Yes, Judge.
Okay, before I call the calendar, are there any additional announcements? All right, position 1, 24 SC 005002, Keontae Smith.
I'm here, Judge.
Yes, Judge. And he's also position 2.
Okay, that is 26 SC 001861 for Mr. Smith. So where are we on position 1?
We are going to pre-try. I sent an email to the state last night. He also has an additional indicted non-complex matter that's not on the calendar. And I emailed Attorney Bray about all 3 of those cases. So we'll pre-try.
Okay, all right. All right, so y'all are working potentially towards a global resolution on Mr. Smith's cases.
Yes.
Yes, Judge.
Thank you. Position 3, 25 SC 001003, Tiani Kears.
Yes, Judge, that's my case. We are in pre-trials with the state. We should be able to come to some resolution today.
Okay,
And Your Honor, any of the cases on the calendar where it mentions status of adult diversion, I did send a list to Mr. Pollard in the DA's office. He's the one that makes the determination on who's accepted and who's not. I
Okay.
did send that out to him last night, a list of every single person that's on this calendar that's supposed to be in diversion, to see like what is he missing, why hasn't he made a decision. But
Okay.
yeah, so I'm waiting to hear back from him. So,
Okay, thank you. So, when you connect with him, we'll have an announcement for that. But for now, I understand that y'all may be working on a resolution on position 3, position 4,
yes.
25 SC 001022, Levy Welch.
Good morning, Judge. Mr. Welch is present on the Zoom. We had a potential resolution at the last court hearing, pending some documentation. I sent that over to Attorney Bray last night with an email regarding our last conversation. So we'll pre-try on that case as well,
Okay.
and hopefully have a resolution today.
All right. That brings us to position 5, 25 SC 001061, Mia Robinson.
We'll be pre-trying, Your Honor.
All right. 6, 25 SC 001427, Carlisle Alvarez.
Yes, Judge, and Mr. Alvarez is present on the Zoom as well. We will pre-try on that one. I also sent a separate email to Attorney Bray regarding this case.
Okay. Position 7, 24 SC 004442, Renisha Brown.
Her case was moved to the August 5th calendar to be heard with the co-defendant.
August 5th.
Yes, Judge.
Thank you. 8, 25 SC 001466, Gerald Hill.
Pre-trial, Your Honor.
Thank you. That brings us to 9, 25 SC 001973, Joseph Demond.
Good morning, Judge. Attorney Courtney Shelton for Mr. Demond. I will say pre-trial, we've sent over exculpatory evidence to the prosecutor. So I'm just not sure if they've had a time to review that.
Okay, you sent that to
Ms.
Attorney
Bray,
Bray?
they did, Your Honor. I did receive a slew of emails yesterday, so
Okay,
I
I
just need to
understand.
pull it up and look at it. But I remember discussing this case with Mr.
Uh,
Rosenblum, and it was going to be a potential no pros, but because he had to send me certain information. But yes.
Okay, so we'll let you digest that, and I'll wait for an announcement on that from you and Ms. Shelton.
Thank
Okay.
you, Judge.
10, 25 SC 001993, Talandor Dermas.
And that's my case, Judge Chad Trinacosta here. And Miss Bray and I had pre-tried this case last time, and I needed to send her something from the victim, which I've already sent. So I believe the case should be no pros.
Okay. When did you send
And
it?
well, she sent it a while ago in CCS, but I just sent it this morning, so it should be
Thank
probably
you.
about 5
Thank
minutes
you.
ago, so it should be
Okay.
there, so we can
Thank
get
you.
that closed.
All right.
All right, thank you. So we'll give Attorney Bray an opportunity to find that, and I'll wait for an announcement. 11, 25 SC 002086, Luis Martinez.
Pre-trial, Your Honor.
Okay. All right, and good morning. I see him on the Zoom as well. All right. 12, 24 SC 003869, Amber Sean Davis.
Yes, and she's also position 13. We also had some prior negotiations at the past court hearing. And the district attorney Bray wanted to make a call to the victim prior to finalizing it. I sent all of that in an email as well. I sent all these emails at like 11 o'clock last night, so I didn't expect
Right.
Attorney Bray to have responded yet.
I need
But we'll
time to
pre-try.
look at it, but we'll take care of it.
Okay, that applies to 12 and 13, which is 13 is 24 SC 004735. I'll wait on an announcement. 14, 25 SC 002089, Maya Dowdle.
It's Dowdell, Your Honor. Attorney Andre Smith here for my client.
And that will be a no pros, Your Honor. It's been outstanding. So I will get to that today.
Okay.
And and Ms. Bray, I understand you said that, but I just
Yeah.
want to make sure it's done because we've been waiting since May 14th on that matter.
Okay. Okay.
Will it actually be done today?
It'll be done today, yes.
Okay. All right.
At 14 is a null frost. Thank you. 15, 25 SC 001263, Dondria Livingston.
Yes, Judge, and I'm just covering this announcement for Attorney Salfarazi, but it is also pending a no pros from the state on this case, and Miss Livingston's was excused.
Okay. All right, I'll get that in today.
Okay, so that one is also a null pros.
Yes, Your Honor.
Right, 16, Mr. Barry's matter, we handled that earlier. Y'all confirmed that was a null pros as well. Okay, so at this time, that concludes the pretrial conference portion of the calendar, and you all need time to pre-try the cases. So at this time, unless there are any announcements, the court will be in recess while you all discuss the cases.
Your Honor, should I come back for the plea at what time? My apologies, Judge.
Miss Ennis, can you send me the terms of the plea? Did you work out that plea with me, or did you
Yes.
work it out with Mr. Malcolm? Just send me the terms, honey.
Mr. Malcolm, you want me to send it in the? I'll
You
send
worked
to
it
you.
out with Mr. Malcolm?
Yes.
Okay, then I don't have it. Please send me the terms and I will honor it, of course. So just send it to me and I'll
Okay. I'll figure out how to do it directly to you.
Okay.
ADA
All right.
break. Did you want a breakout room with anyone or any attorneys want a breakout room?
If you
That's
give me
easier.
a breakout room with each of the private attorneys, I will do the null pros while I'm talking to them.
Okay.
And we can be done. Okay. All right.
We can
So
do
just give me a
that.
breakout
All
room.
right.
Yeah,
Yeah.
give me a
Thank you.
breakout room and we can do it.
Okay. Are there any other announcements before we are in recess? I will listen out for announcements.
Ray, I'll just email you about my cases. And
Okay.
we'll
Okay.
try and do it that way. Okay.
All right. Thank you.
Okay, thank you. All right, hearing no other announcements, I will allow you all to meet with the ADA
Okay.
and the court will be in recess.
All right.
How long is recess?
Demetrius, we're at the mercy of the court. I'll call you. Put yourself on mute and you can take off the camera.
Hi, is someone available from the courtroom?
Yes, ma'am.
Hi, Attorney Courtney Shelton here. I just spoke with the prosecutor and she submitted a null pros on Joseph Demond.
Okay, one moment.
She just emailed it over.
All right, that's position 9.
Yes.
I have that down as a null pros. Thank you, Attorney Shelton.
Thank you, Judge. May I be excused and my client be excused?
Ms. Moore, do you need anything further? The process? Okay. Thank you. Have a good weekend.
Thank you, Mr. Demond. I'll call you shortly.
Okay,
All right,
thank you.
9 is a null pros.
Thank you.
And Judge, are we able to make announcements?
Yes.
Yeah, this is
Morning
Chad
again. You
Trinicosta.
have an announcement?
Yes. Yes, position 10, the null process has just been submitted. It was emailed over.
Okay. So position 10 is a null pros. Thank you.
Yes, ma'am. And may my client and I be excused?
Of course. Have a good weekend.
You too. Thank you.
All right. Attorney Glaves Ennis, were you on?
Yes,
for
Your
the
Honor.
motion Also?
Yes, Judge, we are ready for a plea at the court's convenience. My client will turn on his camera and we are ready whenever the court is ready.
88 Bray, we ready to proceed with the plea on the add-on? Oh, you're on mute still.
Yes, ma'am. Yes, Your Honor.
Good morning, sir. Just a moment. 88 Bray?
Yes, Your Honor, I'm here. Let's see, what am I looking for? Hold on. But I did speak with Miss Attorney Glaves Enos. We are ready. I did find the probation officer. I did find the notes from Deputy DA Malkin, so I know what the offer is. I hate to say I need to look up the maximum for this offense,
It's
unfortunately.
20 years.
It is 20 years. Okay, so that's why
5 to
you're
20.
20.
Mm-hmm.
Okay,
5 to 20.
gotcha.
Yep.
5 to 20. All right, then
All right.
we are good to go, Your Honor.
All right, so the court is going to call 25 SC 004945 Demetrius Jackson, who has been charged with cargo theft valued at more than $1,500. Mr. Jackson, good morning again. Can you please take your device off of mute?
Correct. Thank you, Your Honor.
All right, and you can hear everything okay from where you are?
Yes, ma'am.
All right, thank you. At this time, can you please be sworn in?
Raise your right hand, Demetrius. Do you want me to swear in, Judge?
I'll do it. Do you swear or affirm that the testimony you are about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you can lower your hand now. State your true, correct, and legal name for the court, please.
Demetrius Jackson.
Okay, do you have a middle name?
Darnell.
And spell that.
Darnell.
Okay. Are you at this time taking or under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there a medication that you should have taken today that you have not taken?
No, ma'am.
Okay. How old are you and how far have you gone in school?
I am 35 years old. I completed high school and I also completed North Academy Trucking Academy. I also completed Cornell University Agriculture. I have a degree in agriculture and farming.
Okay. So you are able to read, write, and understand the English language, correct?
Correct. I am American.
Okay. Do you understand that you are charged with one count of cargo theft valued at more than $1,500?
Correct.
Do you understand that you have the right to plead either guilty or not guilty to this charge? And if you plead not guilty or you remain silent, you may receive a jury trial.
Okay.
I'm just saying, do you understand that?
Gotta
Yes.
say yes.
Okay. Have you reviewed the plea of guilty form with your attorney?
Yes.
Did you understand everything on the form?
Yes.
Okay. Do you have any questions about anything on the form?
Yes.
Okay. Then you might need to speak to Attorney Glaze Ennis to answer your questions.
I spoke with her, so I'll speak to her after this. So far I'm
Demetrius, I think he's nervous. We went over the plea form and the questions. Do you understand the form that we went over when we talked yesterday and on Saturday? I
Okay.
think he's a little nervous.
Okay. Have you
I
had
have.
enough time to speak with Attorney Glaze Ennis about your case, including any possible defenses you might have?
Yes.
Do you need or want more time to discuss the case with your attorney before proceeding further with this plea?
No.
Are you satisfied with her services?
I am.
Okay. Counsel, do you waive formal reading of the indictment and any defects that may be in the indictment?
Yes, I will waive it.
Have you gone over all your client's rights with him and did he appear to understand them?
Yes.
Okay. Now, Mr. Jackson, you were in fact arrested on this case, correct?
Yes.
Okay. Your Honor, at this time, the state is unaware of any outstanding warrants related to this case. So I'm now going to ask Attorney Glaves Innes, are you aware of any outstanding warrants related to Mr. Jackson's case?
I am not. He was arrested and made bond on this case.
Okay. Now, Mr. Jackson, the minimum you can receive for this felony charge of cargo theft is 5 years. The maximum sentence you could receive is 20 years. Any portion of that sentencing range can be on probation, it can be suspended, or it could require time in custody. Do you understand your sentencing range?
Yes.
Okay. Now, this is a negotiated guilty plea, which means that you, through your attorney and the state, have reached an agreement on how to best resolve this case. And now the state is presenting that agreement to the court for the court's consideration and approval. The court is not required to follow the agreement and will sentence you within the range that we just discussed. Do you understand?
Correct.
Okay. Do you understand that this is a Okay, I'm not going to read that part because it won't be permanently recorded. Okay. Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering this guilty plea?
I am not on any probation or parole.
Okay. Do you understand that if you are placed on probation, you cannot violate the criminal laws or any special conditions of your sentence without being subject to having up to the balance of your sentence revoked?
I don't know what half the language mean, but I guess I understand.
No, that's
I'm
Demetrius,
sorry. Yes.
we
okay. Do
talked
you need
about
to
this. You understand?
Yes.
I'll defer to you, Judge Treadwell. Do we
Okay,
continue or do we put them in a
so,
breakout room maybe?
I was actually just going to suggest that, Ms.
Yeah.
Glaves, Ennis, and Mr. Jackson, I'm going to ask that you go, into a breakout room. I understand that you all had some previous conversations, but the court, needs to be satisfied that Mr. Jackson fully understands, the nature of the plea and the potential outcome. So if we could please put them in a breakout room and if you all can, and then you all can return.
Thank you, Judge.
All right, thank you.
Attorney Bray, while they're talking, do you want to go into a breakout room or do you want to just check the emails when you are done with
Well,
that?
that's what I was doing, checking emails, but I'm trying to finish up the null pros on the Maya Dowdell case. I did respond to all of Showalter's cases, so hopefully those will be resolved today by way of a plea. I guess he's discussing them, the solutions with his clients now.
Yes, I'm talking with them right now about it.
Okay, good. Is Attorney Andre Smith still on? Did he get off?
No, ma'am, I can get him back on. I know he's in court right now in Coweta County, but I can call him to tell him to log back in.
All right. I just need to know which of the co-defendants is currently in prison regarding the Maya Didell case.
Quentin Potts.
Oh, that's the one. Okay, thank you. All right, so I'm drafting that now, so I can close that out.
Okay.
I'm back, Miss Bray. My apologies.
Okay, if we are ready to resume, I have a few questions for the record. Mr. Jackson, if you could please take your device off of mute. Without telling me anything that you discussed, did you have an opportunity to discuss this plea again with your attorney in the breakout room a few moments ago?
Yes, Your Honor.
Okay, and you were able to ask questions and you understood her answers?
Yes, Your Honor.
Okay. And you wish to proceed this morning with the plea?
Yes, Your Honor.
Okay.
Okay, 1 second. I'm sitting in one of those no process. Hold on. So I'm
Okay.
just press in and send this out there. I
AJ
don't have, yes.
Oh, when you're ready for Mr. Jackson, I just wanted to ask you to go back to the portion of your plea colloquy regarding the revocation. If you could pick up there,
Okay,
because that's where I think
the confusion
questions
came.
arose initially.
Yes. Okay. Mr. Jackson, do you understand that if you are placed on probation, you cannot violate the criminal laws or any special conditions of your sentence without being subject to having up to the balance of your sentence revoked?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which carries a significant sentence that could be up to 15 years in prison?
Yes.
Do you understand that if you are not a United States citizen, this guilty plea will affect your immigration status and will result in deportation?
Yes.
Now, I understand that you are asking to be treated as a first offender under the provisions of the First Offenders Act, correct?
Yes.
Have you ever pleaded guilty, nolo contendere, or no contest to, or ever been convicted of a felony in the state of Georgia or in any other jurisdiction?
No.
Have you ever been sentenced for any crime, felony or misdemeanor, under the First Offender Act?
No.
Has your lawyer explained the First Offender Act to you?
Yes.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked and you could be adjudicated guilty and you could be resentenced to up to the maximum sentence for each charge to which you are pleading guilty today?
Yes.
All right. Do you understand that you waive or give up any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes.
All right. I'm going to go over the following rights with you. All right. You have the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront the state's witnesses against you, the right to assistance of counsel hired by you or to court appointed counsel if you cannot afford an attorney and you request one at a trial of your case. You have the right to the presumption of innocence. You have the right to subpoena witnesses and to compel the production of evidence. You have the right to testify on your own behalf and to present other evidence. You have the right to have the charges against you proved beyond a reasonable doubt, and you have the right to appeal if convicted of these charges after a trial. Do you understand all of these rights I have explained to you?
Yes.
Do you understand that you are giving up all these rights by entering into this guilty plea?
Yes.
Now, do you waive or give up your right to have a more formal restitution hearing?
Yes.
Okay. Do you waive your right to have the court make written findings of fact pertaining to the restitution?
Yes.
Okay. Do you agree that for this guilty plea, the restitution amount, let me pull that up. Ms. Ennis, what was the restitution amount?
50,000.
All right. The
No, I'm
restitution.
sorry. Hold on. I'm sorry. That's the fine. The restitution amount, I believe, was $15,000.
Okay. And with that amount to be paid at a rate of what, 218 a month?
Yes.
Okay. Until the balance is met. Do you agree to that arrangement?
Yes.
And do you agree that you will have the ability to pay this restitution over the course of the sentence and you will use your best efforts to pay?
Yes.
All right, hold on 1 second. I happen to have dropped the calendar. Now, has anyone forced, threatened, or promised you anything to cause you to enter into this guilty plea?
No.
Are you entering into this guilty plea freely, voluntarily, knowingly, and intelligently?
Yes.
Okay. Now, do you understand that you have 4 years from today in which to file a habeas corpus petition challenging the voluntariness of your guilty plea.
Yes.
Okay. Are you entering this guilty plea because you have decided that it is what you want to do after discussing the case fully and to your satisfaction with your attorney and after thinking about the case yourself?
Yes.
Okay. So, Mr. Demetrius Darnell Jackson, under indictment number 25SC 004945, how do you plead to the one count of cargo theft with a value more than $1,500?
Guilty.
Are you in fact guilty of this offense?
Yes.
Okay. Is the state stipulating to the factual basis of this case?
The defense, yes.
I'm sorry, the defense. Sorry about that.
Yes,
All
so
right,
stipulated.
stipulating, Your Honor, and all the everything took place in Fulton County. Your Honor, is my understanding that the state was offered by a prior ADA, Deputy DA Brad Malkin, 20 years probation under first offender. It says here a $50,000 fine because that's the statutory minimum for this particular fine. He must pay at least $210 per month, along with 200 hours of community service. He must complete at least 100 hours every 6 months. Fourth Amendment waiver applies. He must submit to a drug evaluation and treatment. He's also subject to random drug and alcohol screens. He is to have no guns, no drugs without a prescription. This is under First Offender Act statute. I believe the behavioral incentive date is 3 years. The probation may terminate after 5 years if all conditions are completed. And that is what I am seeing here.
Okay, thank you, ADA Bray. Attorney Glaves Ennis.
Your Honor, this is a negotiated plea. My client, as he said earlier, is 35 years old. He does have some college. He is the father of 4 children. He is an over-the-road truck driver. The previous ADA was aware of this, and I asked Attorney Bray this morning if she would consent once he makes his first probation meeting that he could be allowed to report by phone or email. My understanding is that she has no objection, Judge. He is asking to be sentenced as the first offender, and all the other terms are as negotiated, Judge.
Okay, thank you. And I need to confirm ADA Bray and Attorney Glaves Ennis. Did I hear correctly that there's a payment of $210 per month?
That is correct, $210 per month.
And that's for the fine?
That's for the fine.
And then $218 for the restitution?
Your Honor, I just look back at my notes. There is no restitution. There's no restitution break because they were
Okay.
able to recover the items. My apologies. There's no restitution. So it is $210 a month towards the fine.
And I need to be clear, y'all are, well, Deputy Malkin stated that 50,000 is the minimum
Yes.
statutory requirement
Yes.
fine. Okay, I just want to be sure. So I never would have asked for that, but okay.
Okay, and 20 years probation under first offender?
That is correct, Judge. With a BID, 3 years BID and 5 years termination if he's completed all the requirements.
Mhm. All right, at this time, may I please hear from pretrial? Did I see that Ms. Harvey was with us?
Yes, Your Honor. Good morning.
Good morning.
Yes, 9 cycles out of Georgia and 1 cycle out of North Carolina. Does not appear to have any prior felonies and nothing further.
thank you. And the items were recovered?
Yes, the items were recovered. Yes, yes, Your Honor.
Okay, thank you. Mr. Jackson? Based on your testimony, the court finds that you understand the nature of the crimes and the consequences of your guilty plea. I find that there is a factual and legal basis for that guilty plea based on the facts presented and the stipulation between the parties. I'm going to ask you again if anyone has forced you or if you feel rushed. I see that you're at work to accept this plea today.
No, I'm entering it free and voluntary.
Okay. And so the court does find that you are entering this plea knowingly, intelligently, and voluntarily. As a result, the court will accept your plea as well as the sentencing recommendation, which is 20 years on probation under the First Offenders Act, 200 hours of community service, no drugs, no weapons. You'll be subject to random drug testing. You will agree to a Fourth Amendment waiver. There is a fine of $210 per month. And the court will agree to the bid date or period for 3 years. In addition, after your first meeting with probation, you may report by phone or email. I'll let them determine which method they prefer. But after your first meeting, you may report that way due to the nature of your profession.
Your Honor,
Yes?
I did speak with my attorney about it, but the only thing I'm confused on, how I'm gonna be doing something random if I'm traveling abroad, moving America forward. My schedule. That's why I asked if I can report on the phone because I just don't be in Georgia.
I think he's referring to the random drug screen, Judge,
Right.
because he drives over the road.
Right, and so I can't speak for probation, but that is something that they will work out with you. You are to keep them apprised of your schedule. And okay, you have your hand up again.
I work 21 days out of the month, sometimes 25, and I never know where I'm going. I just get dispatched.
Okay, but
Okay, Your Honor, to better assist in just moving this case along, I want to withdraw the 200 hours of community service. If we
Okay.
could delete that, because if he's on the road, no, I don't like community service hours anyway. So I want to delete the 200 hours of community service. I'm fine with him just doing a drug and alcohol evaluation one time. And if that evaluation indicates that he needs treatment, then fine. But if not, then he wouldn't need it. I don't know. Maybe probation is on. They're probably on. If they can tell us that random urinalysis is just something that they do anyway. If it's not something that they do anyway, then I would withdraw that because I understand that he's a long distance truck driver.
Okay, so typically what happens, this is Miss Jolly, felony probation. Typically what happens is it's up to the discretion of the officer. Upon his first initial contact with his officer, he can make them aware that he is over the road. These are his things. Of course, we want to make sure that he still remains employed. He has to be forthcoming with that information and according to his schedule and according to that, because we want him to remain in compliance. Then at that time, they will probably schedule it or probably do a pop-up house visit. I'm not really sure, but he just has to make sure that his contact information is up to date. And it is stated in the disposition as far as him and how often he can and can't report, as well as him being able to still maintain being over the road. And I'm pretty sure the officers will be able to adapt.
Okay.
I just don't want to, I appreciate that. I don't want to set him up for failure. I appreciate you considering that, Miss Bray, because he does drive out of state and he may be in Georgia for just a couple of days. Another thing, Judge, my apologies. I think DA Malkin was incorrect with the plea offer in terms of the fine. It's a mandatory 25,000, not 50,000. I researched that, Judge, and I wanted to confirm that.
Okay, so
You said 25?
Yes, is the maximum, not based on the value of the ATVs.
and I'm fine with that adjustment going downward to 25 because 50, I didn't like that one.
Okay, so is the state is withdrawing the community service?
Yes, Your Honor.
Okay, is the
Thank
state
you.
withdrawing the random testing?
I am, Your Honor. I just didn't know, hold on. Oh, I'm sorry.
Judge, if
I
I
just
could,
didn't know what the policy was with probation itself. That's all I'm saying. But I'm okay with the random urinalysis being withdrawn because he's on the road 21 days. So that doesn't make sense to me that we would have that one for him.
And I can't control the days that I'm out. I could be like, hey, send me home. I'll be stranded.
Okay.
Ms. Moore?
Thank you.
Ms. Moore, were you attempting to speak?
I just wanted to say, so usually on the disposition, if there is a drug and alcohol evaluation, Judge Brooks will just say random drug screens only if treatment is needed.
Oh, okay.
So that's the only time a random screen would come in, only if treatment is needed from that evaluation. I just wanted to put that on the record.
All right, thank you.
Thank you.
ADA Bray, does that change?
That's
your
fine with me, Your Honor.
analysis?
That's fine with me. And I'm even okay if we withdraw the drug and alcohol evaluation. I mean,
I
I'll
think
leave that up to
a
the court.
withdrawal would be great. I'll take that.
Okay, I'm inclined to withdraw it in its entirety, so that will be withdrawn.
Thank you.
On the payment for the fine is still $210 a month, even though the fine amount is not 50,000.
Can we reduce that to 100, Miss Bray?
I'm okay with reducing it to 100, but I'm just thinking the earlier he pays it off, the sooner he could be off probation because I would be amenable to probation terminating upon payment of that fine.
Would you? Okay.
Yeah, I
All
would.
right.
And you
Okay.
said the fine was 15,000 out of 25,000?
It's just 25,000 straight, nothing else. So 25,000. As soon as you pay that off, then you can get off probation.
Yes. And I'm okay with that.
Okay.
Okay, and I understand that that is the minimum fine amount.
That is correct, Judge.
Okay,
So the termination would not be 5 years, but it would be once he's paid the restitution.
Yes. And
Okay.
I would agree to that.
okay.
Thank you so much.
But you're also agreeing, ADA Bray, that the minimum monthly payment is now $100 with the understanding that he can pay that off early?
Yes.
Okay. All right. Okay, do we need to go over the terms again?
That
for
would
the
be
record?
helpful, Judge.
Okay.
Yes.
All
Yes.
righty. So I'm accepting Mr. Jackson's guilty plea, 20 years probation. It's a first offender. I understand the minimum fine amount is 25,000. His minimum monthly payment will be $100 per month. Should he pay that off early? ADA, oh, did we lose ADA, bro?
Oh, she seems to be there with sound. I think it's just her video that seems to be off, Judge.
If he pays that off
Back on.
early, Okay, just making sure if he pays that early, ADA is okay with the probation terminating, is that right?
Yes, Your Honor.
Okay. He will sign a Fourth Amendment waiver. He is to have no drugs, no weapons. And you may report by phone or email. I will leave that up to probation due to the nature of your profession. There will be no random screens or drug evaluation.
And Judge, is there still the 3-year bid date?
ADA Bray,
Yes. I mean, he would have to have that paid off in 3 years, but if he has that fine paid off in 3 years, then yes, I'm fine with the probation
Okay.
terminating.
All right, that's fine. Just wanted to confirm. Thank you, Ms. Moore. All right, is everyone on the same page, including Mr. Jackson, as to the terms of the probation?
Yes, Your Honor.
Yes.
Demetrius?
Yes.
Okay, so I have accepted your guilty plea, and that will be the court sentence.
Your Honor, can I please get Mr. Jackson's contact information for felony probation so that I may tell him where he is to report?
Sure, I was just coming to you.
Oh, thank you. Mr. Jackson, could you please provide me with your contact number, please?
Go ahead, Demetrius. Is he frozen? I can give the number to you.
I'm ready.
Hold on. I just have it saved. 470
Mm-hmm.
721
Mm-hmm.
8006.
Yes, I'm here. My phone overheating.
Okay. Is your contact
My
number
phone
470-721-8006?
Correct.
Okay, you will be receiving after court from felony probation. Please make sure you answer that call so that I can let you know when and where you are to report, okay?
Okay.
Also,
My line will be open.
okay, also, are you still residing at the address that is located on Smoke Creek Parkway?
No.
Okay, you don't have to provide it over the line because this is live stream. I will give you a phone call and get your correct address and let you know when and where you are to report, okay?
Yes, ma'am.
All right, thank you.
Do I have permission to sign the indictment, ADA Bray?
Yes, Your Honor.
Attorney Glaves Ennis, do I have permission to sign?
Yes, Your Honor.
Mr. Jackson, do I have permission to sign on your behalf? The
Yes,
indictment.
Your Honor.
Thank
Yes,
you.
Your Honor.
Right, is there anything further on Mr. Jackson's matter?
Not from
No,
the state, Your Honor.
from the defense, nothing other than to thank the courts for its indulgence and to thank the state for working with us to help to make sure that our client has a fair chance of compliance, Judge.
You're
Thank
welcome.
Okay, Mr. Jackson, we have concluded your matter. If you have any additional questions that pop up after you log off, of course, please reach out to your attorney.
Okay.
Thank you, Judge. May we be
Okay.
excused, Your
Thank
Honor?
Yes, have a good day.
Thank you.
Okay, that concludes Mr. Jackson's matter. All right, I see Attorney Cole and Showalter. You have an announcement?
Judge,
Yeah.
for efficiency of the court, I'm sure Attorney Showalter has pleas ready to go since he was talking to his clients. But if there's a way that I can negotiate with Bray beforehand so that while I can talk to my clients while he's doing his pleas, it might help assist with efficiency.
That makes sense to me. It is.
Makes sense to me if we could get a breakout room. Oh, and I want to, Your Honor, to know I did send in the null pros on Maya Dowdell.
Okay. All right, so the court will be in recess, and then when you return, ADA Bray will take up Mr. Showalter's matters.
All right.
Thank you.
But one of the matters needs further noticed. Maya
Okay.
Robinson, position 5, will be further notice to trial.
Okay, that's, okay, position 5. Ms.
Yeah.
Moore,
Yes, that trial date would be July 27th.
okay, thank you. July 27th on position 5 for trial.
And so she may be excused, right?
Yes. I did not see them. Oh, I do see the cameras off, but Miss Robinson, if you can hear me, you are excused.
Yep. And yep. Positions 8 and 11 will be negotiated, please.
Okay. All right, we will take those up when the ADA returns.
Excuse me, Judge Treadwell. This is Maya. Can I be excused now, or do I need to stay? Maya Dowdell.
The next time, then, wasn't that case null pros? Yes.
Yes, Judge.
But hold on, Miss, I saw your attorney. Is her
Yes.
attorney
Do you want me
Andre
to
Smith?
do you want me to tell him to come back in?
No, I saw him come on, so I didn't know if he had anything
Oh no,
further.
I was just updating him with what y'all was saying.
Oh, okay. All right. So yes, your case has been null pros, ma'am. So you are free to log off.
Okay, thank you.
Thank you.
Hold on, can I be heard? Everybody left? No, I just went quiet.
Mr. Alvarez, we're in recess.
Okay, my bad, my bad.
Judge, I have two announcements and then I can leave the, Justin Showalter should be ready to go forward on his cases, I believe.
Okay, what are those announcements?
Position 3 on the motions calendar, if we could put it on the record.
Okay, position 3 on motions is 18 SC 163310 Sharia Cooper.
Yes, the state has informed me that they're unable to find any of the documents requested. So we are just asking the court to grant the order to exclude it. It's significant financial documents that would take a lot of time to go through. And if they don't have it now, we would just like to further notice for trial and ask that any further discovery be excluded.
ADA Bray.
Okay, yes, I thought we were further noticing it to trial calendar.
Yes.
And what would the trial calendar be?
7/27.
27.
We're also fine if the court wants to give the state a deadline to provide that documentation before then, just knowing that we would need time to review it because it's financial documents.
Okay, ADA Bray, I'll hear from you.
Your Honor, I did email my investigator on June 16th. And because of the age of the case and its documents, you know, it was kind of like a holy grail prayer that he could find it in a week. So I agree with the last statement of Attorney Cole. As soon as we get it, I will give it to her. If it makes a difference, you know, or if we don't get it, then obviously I would end up no processing the case if we absolutely cannot get it. But I think it's due to the age of the case because this is way back in 2018. And I'm thinking that's why you couldn't get it within a week.
Okay.
So, or a little over a week. I think that's why.
All right, if the trial date is the 27th.
Like if my investigator can't get it within the next 2 weeks, I'm just going to go ahead and null process because it's either there somewhere or it's not.
Okay.
Okay.
Attorney Cole, I'm assuming you have no objection there.
We have no objection to that.
Okay, all right.
And there was a motion to reinstate counsel, Judge, but the pro se order never went in officially. So I've just remained as counsel and I came back on the case. So that can be dismissed.
Okay. So you don't need a separate order?
No, because I was never taken off the case officially.
And you know, before we take Showalter's plea, can I have a 5-minute comfort break, please?
Of course. And just really quickly on 3. So if the documents are not produced by the 8th, that would be 2 weeks.
Okay,
Then
that's yes. I'll null process if my investigator can't get what I'm asking for. I'll go ahead and null process. And part of it will be due just to the age of the case. Like,
I understand.
yeah.
And then can I just quickly announce on position 4 on the pretrial conference calendar? And then I know we need a courtesy. That is Levy Welch, and he's present on the Zoom.
He will be a null process, Your Honor. The last night when Amy Cole was working feverishly and sending off all these emails, she did send me the evidence that I had requested the last time. So that's going to be a null process.
Okay, thank you. That I have 4 as a null process. Mr. Welch. I'm not sure if he's at his computer or on his device. I'm not sure if he can hear me.
He was at work, Judge, so I don't know if he stepped away briefly. Oh, he's there, Judge.
Okay. Good afternoon. Good afternoon, Mr. Welch. My name is Judge Treadwell, and the state and your attorney have reported that this case is being null processed or dismissed.
Okay.
Okay. Attorney Cole, did you have anything you wanted to address with him before he logs off?
No, Judge. As soon as I get the order, I'll send it to you so that you have it for your records, Mr. Welch.
Thank you so much. I appreciate you.
You're welcome. No problem.
All right, thank you, sir. You are excused. You may log off when you're ready.
Thank you.
All right. Judge, can I make a quick announcement on position 3 on pretrial conference?
Sure.
We're asking to be further noticed, just to wait on the decision from diversion so that we're not hanging out all day with the possibility that they may or may not respond. So if we could just be put on the trial calendar, I think we should have a diversion response by then.
Okay. Would that be the 27th?
Yes, ma'am.
All right, July 27th.
Okay, Ms. Kears, did you get that date?
Yes, ma'am, I did.
Okay, perfect. Thank you, Judge, and may we be excused.
Of course, you and Ms. Kears, y'all are excused. Have a good day.
You as well. Thank you.
Thank you, you too.
Can we have that comfort break now?
Yes, I was just making sure everyone. Okay, we will be in recess, and when we come back, we will take up Mr. Showalter's matters. All right, thank you. Are the parties ready to proceed?
I mean, I am.
All parties are present.
My apologies, Your Honor. Is this a misdemeanor plea or a felony plea?
It is a misdemeanor.
Thank
Thank
you.
you.
We're going to start with position 8. And the court calls position 8, which is 25 SC 001466 for Gerald Hill, who has been charged with criminal damage to property in the 2nd degree. Good afternoon, Mr. Hill.
Good afternoon, Your Honor.
Okay, if you could be sworn. ADA break, can you adjust the lighting?
Oh, sorry. Yes.
It's okay.
There you go. Sorry about that.
That's all right.
We get police sheet now. Here. Mr. Gerald Hild, could you raise your right hand, please? Do you swear or affirm that the testimony you are about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your true, correct, and legal name for the court, please.
Gerald Edward Hill II.
Okay. Mr. Hill, you can put your hand down. Okay. Mr. Hill, are you at this time taking or under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there a medication that you're supposed to take that you're not taking?
No, ma'am.
How old are you and how far have you gone in school?
37 years old, and I obtained a bachelor's degree from the University of Tennessee.
Okay, so you're able to read, write, and understand the English language.
Correct. Yes.
Okay. And you understand that you were originally charged with criminal damage to property in the 2nd degree, but to date, the state is willing to reduce that to a criminal trespass.
Yes.
Okay. Do you understand that you have the right to plead either guilty or not guilty to this charge? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Okay. Have you reviewed the plea of guilty form with your attorney, Mr. Showalter?
Yes, I have.
And did you understand everything on the form?
Yes.
Do you have any questions regarding anything on the form?
No.
And have you had enough time to speak with Attorney Showalter about your case, including any possible defenses you might have?
Yes.
Do you need or want more time to discuss the case with your attorney before proceeding further with this guilty plea?
No.
Are you satisfied with his services?
Yes.
Counsel, do you waive formal reading of the indictment and any defects that may be in the indictment?
Yes.
Have you gone over all your client's rights with him, and did he appear to understand them?
Yes.
Mr. Hill, you were in fact arrested on this case, correct?
Correct.
Mr. Hill and Attorney Showalter, are either of you aware of any outstanding warrants related to this case?
No.
You, Mr. Hill?
No,
Okay.
there's no.
And Your Honor, at this time, the state is unaware of any outstanding warrants related to this case. Now, Mr. Hill, the minimum you can receive on the reduced charge of criminal trespass is 1 day. The maximum you could receive is 12 months. Any portion of this sentencing range could be spent on probation, it could be suspended, or it could require time in custody. Do you understand?
Yes, ma'am.
Okay, now this is a negotiated guilty plea, which means that you, through your attorney, and the state have reached an agreement on how to best resolve this case. We are now presenting that agreement to the court for the court's consideration and approval. The court is not required to follow the agreement and will sentence you within the sentencing range we just discussed. Do you understand that?
Yes.
Do you understand that this is a guilty plea which will be permanently recorded on your criminal history?
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering this guilty plea?
Yes.
Do you understand that if you are placed on probation, you cannot violate the criminal laws or any special conditions of your sentence without being subject to having up to the balance of your sentence revoked?
Yes.
Okay. And do you understand that the state is not offering probation? We are offering to, well, it's 12 months probated, but it's suspended upon the
Correct.
condition that you have no further violations of the law. You understand that?
I understand.
Okay. Now, do you understand that if you are not a United States citizen, this guilty plea will affect your immigration status and could result in deportation?
Yes, I understand.
Do you understand that you waive or give up any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes.
Okay, I'm going to go over your rights with you. You have the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront the state's witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney and request one at a trial of your case. You have the right to the presumption of innocence, the right to subpoena witnesses and to compel the production of evidence, the right to testify on your own behalf and to present other evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand all of these rights I have explained to you?
Yes.
Do you understand that you are giving up all these rights by entering this guilty plea?
Yes.
Has anyone forced, threatened, or promised you anything to cause you to enter this guilty plea?
No.
Are you entering this guilty plea freely, voluntarily, knowingly, and intelligently?
Yes.
Do you understand that you only have 12 months from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Are you entering this guilty plea because you have decided that it is what you want to do after discussing the case fully and to your satisfaction with Attorney Showalter and after thinking about the case yourself?
Yes.
Okay. So, Mr. Gerald Hill, under indictment number 25SC001466, how do you plead to the reduced charge of criminal trespass?
Guilty.
Are you in fact guilty of that offense?
Yes.
Is the state stipulating to a factual basis in this matter? I'm sorry, is the defense stipulating to a factual basis in this matter?
Yes.
Okay. And Your Honor, everything took place in Fulton County. Your Honor, the state's offer to the defendant is to reduce the felony charge to a misdemeanor criminal trespass. And it's 12 months suspended upon the condition that he have no further violation of the law. It is my understanding that, Mr. Hill, you still reside at the incident location?
No, I don't. That was at least 3 years ago. I don't reside.
Oh, okay. So you don't anymore. But you did, in fact, resolve the issue of the broken door by paying an additional amount of rent for the
Correct.
broken door?
Correct.
Okay. So is that reason why we are not seeking restitution in this matter, Your Honor? And we are asking that Your Honor accept this plea.
Thank you. Mr. Showalter?
We ask the court to accept this plea as negotiated.
Thank you. May I hear from pretrial, please, Ms. Harvey?
Yes, Your Honor. Multi-state offender. A total of 15 cycles out of Georgia, New Jersey, Florida, Ohio, and Tennessee. He was sentenced in 2025 for aggravated assault out of DeKalb County. Appears to still be on probation for that case, Your Honor. Nothing further.
Thank you. Okay, Mr. Hill, good afternoon again. I understand that you wish to plead guilty to misdemeanor criminal trespass. Is that right?
Yes, Your Honor.
And so the court, based on your testimony, I find that you understand the nature of the crimes and the consequences of your guilty plea. I also find, based on the stipulation, that there is a factual and legal basis for that plea, and that your plea is made knowingly, intelligently, and voluntarily. For those reasons, the court will accept the plea as negotiated, which includes the sentencing recommendation, so criminal trespass misdemeanor, and 12 months probation to be suspended on the condition that there are no further violations of the law.
Yes, thank you, Your Honor.
Okay. Mr. Showalter, did you have anything further?
No.
Okay, may I sign the indictment on your behalf?
Yes.
ADA Brave, may I sign the indictment on your behalf?
Yes, Your Honor.
And Mr. Hill, may I sign the indictment on your behalf as well?
Yes, Your Honor.
Thank you. All right, I have accepted your plea, sir. So that concludes your matter before the court.
All right. You have a great day.
All right, you too. Take care. Okay, we can move to position 11. 25 SC 002086, Luis Martinez. Good
Yes,
afternoon,
ma'am.
sir.
Good afternoon.
All right, the court has called your case. The charges here are criminal damage to property in the second, hit and run, and reckless driving. I understand that the parties have reached a negotiated plea. Is that correct?
Yes.
We have, Your Honor, and my only concern now, looking at the hit and run, like I cannot at this moment put my hand on my red book to see if there was some kind of required something in the statute.
What I saw was that this particular one is being charged under subsection C1A. So it's not serious injury or damage to vehicle, which is driven or attended by a person, up to 12 months, and or mandatory $300 to $1,000 fine.
But it
So
says and or. It doesn't say that the fine has to be.
correct.
Okay. I just want to be sure, Your Honor.
Oh, thank you.
All right, so we're good.
All
I'm
right.
not asking for the fine.
All right, if we
Okay.
are ready to proceed, if you would swear in Mr. Martinez.
Yes, Mr. Martinez, would you raise your right hand, please? Okay. Do you swear or affirm that the testimony you are about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please state your true, correct, and legal name for the court.
Luis Arvalo Martinez.
Okay, you can put your hand down. Thank you.
Oh,
Okay. Are you at this time taking or under the influence of any alcohol, drugs, or medication?
no, ma'am.
Is there a medication you should have taken today that you have not taken?
No, ma'am.
How old are you and how far have you gone in school?
I am 29 years old and I finished the 11th grade.
Okay. So you're able to read.
Well,
Okay. I'm sorry.
no, go ahead.
Okay.
I was just saying I stopped at 12th.
Okay. So you're able to read, write, and understand the English language?
Yes, ma'am.
Okay. Do you understand that you were originally indicted for criminal damage to property and in second degree a felony, but the state is willing to reduce that to a misdemeanor criminal trespass?
Yes, ma'am.
And the other charge was hit and run, duty of driver to stop at or return to scene of accident. And count 3 was misdemeanor reckless driving. You understand? Okay.
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you reviewed the plea of guilty form with your attorney?
Yes.
Did you understand everything on the form?
Yes.
Do you have any questions about anything on the form?
No, ma'am.
Okay. Have you had enough time to speak to Attorney Showalter about your case, including any possible defenses you might have?
Yes, ma'am. Yeah.
Do you need or want more time to discuss the case with Attorney Showalter?
No, ma'am. I think we're in understanding.
Okay. Are you satisfied with his services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment and any defects that may be in the indictment?
Yes.
Have you gone over all of your client's rights with him? And did he appear to understand them?
Yes.
Okay. Now, Mr. Luis
Yes, ma'am.
Martinez, you were in fact arrested on this case?
Correct.
Okay.
Yes.
Attorney Showalter and Mr. Martinez, are either of you aware of any outstanding warrants regarding this case?
No.
Martinez?
Not from my understanding, no, ma'am.
Okay. And Your Honor, at this time, the state is unaware of any outstanding warrants related to this case as well. Now, Mr. Martinez, for each of your 3 misdemeanor charges, the minimum you could receive as a sentence is 1 day. The maximum is 12 months. Any portion of this sentencing range can be on probation. It could be suspended, or it could be time spent in custody. Do you understand?
Yes, ma'am.
Now, this is a negotiated guilty plea, which means that you, through Attorney Showalter and the state, have reached an agreement on how to best resolve this case. And we're now presenting that agreement to the court for the court's consideration and approval. The court is not required to follow our agreement and can sentence you or will sentence you within the range we just discussed. Do you understand that?
Yes, ma'am.
Do you understand that this is a guilty plea which will be permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering this guilty plea?
Yes, ma'am.
Do you understand that if you are placed on probation, you cannot violate the criminal laws or any special conditions of your sentence without being subject to having up to the balance of your sentence revoked?
Okay. Yes, ma'am.
Okay. Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Okay. Do you understand that if you are not a United States citizen, this guilty plea will affect your immigration status and could result in deportation?
Yes, ma'am.
Do you understand that you waive or give up any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes, ma'am.
Okay. You have the following rights: the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront the state's witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney and you request one at a trial of your case, the right to the presumption of innocence, the right to subpoena witnesses and to compel the production of evidence, the right to testify on your own behalf and to present other evidence, the right to have the charges against you proved beyond a reasonable doubt, the right to appeal if convicted of these charges after a trial. Do you understand all of these rights I have explained to you?
Yes, ma'am.
Do you understand that you are giving up all these rights by entering this guilty plea?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to cause you to enter this guilty plea?
No.
Are you entering this guilty plea freely, voluntarily, knowingly, and intelligently?
Yes, ma'am.
Do you understand that you have 12 months from today in which to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Are you entering this guilty plea because you have decided that it is what you want to do after discussing the case fully and to your satisfaction with your attorney and after thinking about the case yourself?
Correct. Yes, ma'am.
Okay, so Mr. Luis Arevalo Martinez, in indictment number 25SC002086, how do you plead to count 1, which has been reduced to a misdemeanor criminal trespass?
Guilty.
How do you plead to count 2, hit and run, duty of driver to stop at or return to scene of accident?
Guilty.
How do you plead to count 3, misdemeanor reckless driving?
Guilty.
Okay. And are you in fact guilty of all 3 of these misdemeanor offenses?
Yes, ma'am.
Your Honor, I'm sorry. Defense Attorney Showalter, is the defense stipulating to the factual basis?
Yes.
And Your Honor, all of this took place in Fulton County. Your Honor, the state's tendering this plea. The offer is 12 months probation for each count, all counts to run concurrent. The defendant will not be able to possess a gun while on probation. The defendant is to have no drugs unless with a valid prescription, and no further violation of the law while he completes this 12 months probation.
Thank you. Attorney Showalter?
We're asking the court to accept this plea as negotiated.
Thank you. Ms. Harvey, is there a history that you can provide to the court?
2 cycles, Your Honor, does not appear to have any prior felonies, and nothing further.
Okay, thank you. Hey, good afternoon again, Mr. Martinez. I understand that you are pleading guilty to criminal trespass. Is that correct?
Yes, ma'am.
Hit and run. Is that correct?
Yes, ma'am.
You're also pleading guilty to reckless driving. Is that correct?
Yes, ma'am.
Okay, based on your testimony, the court finds that you understand the nature of the crimes and consequences of your guilty plea. I find based on the stipulation, there is a factual and legal basis for that plea and that you have made this decision knowingly, voluntarily, and intelligently. So the court will accept the plea as presented, which is on each count 12 months probation to run concurrently. You are to have no firearms, no drugs without a valid prescription, and no other violations of the law. Were there any other conditions?
No, Your Honor.
Okay. 88 Bray, may I sign the indictment on your behalf? Excuse me.
Yes, Your Honor.
Okay. Mr. Showalter, may I sign the indictment on your behalf?
Yes.
Mr. Martinez, may I sign the indictment on your behalf?
Yes, Your Honor.
And before we conclude, Ms. Moore?
Oh, yes, I just wanted to say, Judge, Attorney Showalter, I sent you the contact sheet for misdemeanor probation. So if you could just fill it out and just send it back to me as soon as we get done, and I can send it over to them.
Okay. Yeah, I see it. I got it.
Okay.
Thank you, Ms. Moore.
You're welcome.
Okay, sir, I have accepted your guilty plea as presented, so that concludes this matter, and you are free to log off of the Zoom.
Okay. Thank you. I just have one question.
Sure.
So in regards to probation, yeah, they would be reaching out to me. I would be getting a letter, or do I have to present myself or anything like that, or how do we go about that?
Ms. Moore, did you want to respond?
Yes. So Mr. Martinez, so once Attorney Showalter, once he fills out the contact sheet I send him, he'll send it back to me and I'll forward it to misdemeanor probation. So they'll actually be calling you. So it may be from a number that you don't recognize, but just answer it because it could be misdemeanor probation. But they will be reaching out to you via cell phone.
All right. I appreciate that. Yeah. I mean, there might just sometimes I'm working, and so it's difficult to hear the phone at the job site, right? So I'll definitely keep an eye out for that, and thank you.
Okay, did you have any other questions, sir?
No, ma'am. Thank you.
All right, that concludes your matter. You take care.
All right. Y'all have
Well,
one for the.
Martinez, I'm going to call you in a second here so I can fill this thing out for you, okay?
Sounds good. All right.
Okay, Attorney Cole.
Thank you, Judge. I'm ready on all of my remaining cases. I don't know if you just want to go from the top of the calendar down.
Okay, that's fine. The court is going to call position 1. That is 24 SC 005002, Keontae Smith, who has been charged with possession of cocaine, possession of a firearm, possession and use of drug-related objects, and a seatbelt violation.
He's also position 2, Judge.
And position 2, thank you, is 26 SC 001861 for Mr. Smith. There's 1 count for possession of controlled substance, Schedule 1 or 2 with intent to distribute.
Yes, Judge. And then, I'm sorry.
No, go ahead.
Yeah,
also
on position 2, we're reducing that to just simple possession of a controlled substance in Schedule 1 or 2. We're getting rid of the with intent to distribute.
Okay. Okay, Ms. Cole.
And then there is another case that he has that we're resolving today. And that's 26 SC 002236.
2236?
Yes.
Okay.
And I believe Attorney Ray is going to submit a null pros on that case.
I will be, Your Honor. This is one of the emails that that was sent to me late last night. And I've had time to review a transcript from a probation revocation that was done, in which another person claimed the gun in the 26 case. They testified before Judge Schwall on that matter. And so I will be attaching the transcript from that hearing to my null pros, and I will cite the 2 pages that I want the court to take note of, and that is the basis for my null prosing the 26 SC case.
Okay, so that case that's ending in 236, that was a firearms charge?
Yeah, 2236. Yes, it was a possession of firearm by convicted felon case in which the firearm fell down the pants leg of the co-defendant. And the co-defendant immediately pointed it out to the police and claimed it because it was on him. And that all came out in the transcript. And so that's why I'm dismissing this case right here.
Okay, so thank you both for that background. So there will be a null pros on 26 SC 002236.
Yes, and I will get it to you today, I promise.
And Judge, on position 1, I believe the state is also null prosing count 2.
Yes, I am.
And they've agreed to consolidate both cases under a conditional discharge plea.
That is correct, Your Honor.
Quick question. Are these felony pleas or misdemeanor pleas?
Felony.
Thank you.
And Miss Jolly, could you send me your email address in the chat, please? I don't know why I don't have it. Okay.
All right, if we are ready to proceed, you can swear in Mr. Smith.
Okay, Mr. Keontae Smith, please raise your right hand.
Yes, ma'am.
All right. Do you swear or affirm that the testimony you are about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please state your true, you can put your hand down. Please state your true, correct, and legal name for the court.
Keontae Smith.
Do you have a middle name, sir?
I do. Keontae Tayshawn Smith. I'm sorry.
Could you spell that middle name, please?
Tayshawn. Tayshawn.
Okay. I'm writing down Miss Jolly's, hold on 1 second for me. Just writing that down. Okay. Sir, are you at this, Mr. Smith, are you at this time taking or under the influence of any alcohol, drugs, or medication?
No, ma'am. I'm not.
Is there a medication that you should have taken today that you have not taken?
No, ma'am.
How old are you and how far have you gone in school?
I'm 24 and completed 10th grade.
I'm sorry, you're 24 and you completed the 8th grade?
No, 10th. 10th.
10th.
No,
Okay, I'm
10th.
sorry.
10th.
I'm
Yes,
sorry.
ma'am.
All right, so
Yes, ma'am.
you're able to read, write, and understand the English language, correct?
Yes, ma'am. I am.
All right. So, do you understand that in case number 24SC005002, you are charged with possession of cocaine, which is a felony. The state
Yes.
is going to null pros, as in dismiss, count 2, possession of firearm or knife during commission, and count 3 is possession and use of a drug-related object, misdemeanor, and count 4 is seatbelt violation, which is also a misdemeanor. You understand?
Yes, ma'am.
And do you understand that in 26 SC 001861, where you were initially indicted for possession of a controlled substance in Schedule 1 or 2 with intent to distribute, the state is going to amend that charge to simple possession of a controlled substance in Schedule 1 or 2.
Okay. Thank
You
you.
understand?
Yes, ma'am. I
Oh,
understand.
okay.
Yes.
Now,
Yes,
do
ma'am.
you understand that with regards to both cases, you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or you remain silent, you may receive a jury trial.
Yes, ma'am.
Have you reviewed the plea of guilty form with Attorney Cole?
Yes, I have.
And did you understand everything on the form?
Yes, ma'am.
Do you have any questions about anything on the form?
No, ma'am, I don't.
Okay. Now, have you had enough time to speak with Attorney Cole about your case, including any possible defenses you might have?
Okay, about it.
I'm
You
sorry,
hear me?
sir.
You hear
Have
me?
you had an okay, there might be an issue here.
Say it again one more
Okay.
time, Ms. Bray.
Okay. Have you had enough time to speak with Attorney Cole about your case, including any possible defenses you might have with regards to each case?
Yes.
Okay. Do you need
Yes,
or want
ma'am.
more? Okay. Do you need or want more time to discuss these cases with Attorney Cole before proceeding further with the guilty plea? I think he said no,
No, ma'am.
ma'am, but it went out. Okay. So are you satisfied
No,
with her
ma'am. Yeah.
services? Okay. Are you
Yes, I am.
satisfied? Okay, good. Phew. Okay. Counsel,
Mhm.
do you
Yes.
waive formal reading of the 2 indictments and any defects that may be in these 2 indictments?
I do for the purposes of the plea.
And have you gone over all your client's rights with him and did he appear to understand them?
I have, and he did.
Okay. Mr. Smith, you were in fact arrested on these 2 cases, correct?
Yes, ma'am.
Okay.
Yes.
Okay. Attorney Cole, as well as Mr. Smith, are either of you aware of any outstanding warrants related to these 2 cases?
I am not.
No.
Okay.
No.
And Your Honor, at this time, the state is unaware of any outstanding warrants related to these 2 cases.
Okay.
Now, Mr. Smith, I must go over the minimum and maximum sentence for each charge in these 2 cases. For the possession of cocaine, in the first case, the minimum is a year based on the amount here. The maximum would be 5. Count 3, the possession and use of drug-related objects, misdemeanor. The minimum is 1 day. The maximum is 12 months. For the seatbelt violation, the minimum is 1 day. The maximum is 12 months. Do you understand?
Yes, ma'am, I do.
Okay. And for the second case, the possession of controlled substance in Schedule 1 or 2, the minimum would be 1 year. The maximum would be 5 years. Do you understand?
Yes, ma'am.
Okay. Now, any portion of that sentencing range could be on probation, it could be suspended, or it could require time served in custody. Do you understand?
Yes, ma'am.
All right. Now, these are negotiated guilty pleas. which means that you, through Attorney Cole and the state, have reached an agreement on how to best resolve both of these cases. And the state is now presenting that agreement or agreements to the court for consideration and approval. The court is not required to follow our agreement and will sentence you within the sentencing range that we just discussed. Do you understand that?
Yes, ma'am.
Okay. Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering this guilty plea?
Hold on. So you said if I'm on probation, it'll be revoked?
Okay. I do understand your situation, sir, because you're currently on first offender probation, but I believe you entered that plea after you were arrested on these two cases,
Yes,
right?
yes,
Right. So
yes.
there should not be a violation of
Okay,
your probation.
okay,
Okay.
thank you. Okay, cool. Okay,
And
thank you.
plus, you've already had a revocation on that prior case that you're on first offender
Yes,
for, and it took into account these
yes,
cases.
ma'am.
There you go.
Okay, yes, ma'am.
Okay.
Yes.
Okay. All right. Do you
All right.
understand that if you are placed on probation, you cannot violate the criminal laws or any special conditions of your sentence without being subject to having up to the balance of your sentence revoked?
Yes, ma'am. I understand.
Okay. Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Okay. Now,
Yes, ma'am. I understand.
okay. Do you understand that by
Yes.
pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which carries a significant sentence that could be up to 15 years in prison?
Yes, ma'am. Yes.
Do you understand that if you are not a United States citizen, this guilty plea will affect your immigration status and would result in deportation?
Yes, ma'am.
Now, it is my understanding that you are asking the court to treat you under the provisions of the conditional discharge statute for each of these two cases, correct?
Yes, ma'am.
Have you ever pleaded guilty, nolo contendere, or no contest, or ever been convicted of a felony in the state of Georgia or in any other jurisdiction?
No, ma'am.
Have you ever been sentenced for any crime, felony, or misdemeanor under the conditional discharge statute?
No, ma'am.
Has your lawyer explained the conditional discharge statute to you?
Yes, ma'am.
And do you understand that if you violate the terms of your conditional discharge sentence or commit a new offense while on conditional discharge probation, your conditional discharge status could be revoked, you could be adjudicated guilty, and you could be resentenced to up to the maximum sentence for each charge to which you are pleading guilty today?
Yes, ma'am.
Do you understand that you waive or give up any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes, ma'am. Yes, ma'am.
All right, I must go over the following rights with you. You have the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront the state's witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney and request one at a trial of your case. You have the right to you have the right to the presumption of innocence, the right to subpoena witnesses and to compel the production of evidence, the right to testify on your own behalf and to present other evidence, the right to have the charges against you proved beyond a reasonable doubt, the right to appeal if convicted of these charges after a trial. Do you understand all of these rights I have explained to you?
Yes, ma'am.
Okay,
Do you
so
understand?
Mr. Smith,
Oh.
I am going to ask, you have been moving around. I'm not sure if you're trying to make sure you get a good signal, but during the proceedings, I need you to be stationary. So
Okay.
pick a spot.
I was
So
just
pick a
trying,
spot and you can stay
I'm
there
trying
for
to
the
make
remainder
sure I
of the
wasn't
proceeding.
freezing.
I'm sorry?
Yes, ma'am.
Okay.
I'm just trying to make sure I wasn't freezing.
Okay. And I'm just asking that you pick a spot and stay there. Okay?
All right. Yes, ma'am. Yes, ma'am.
I don't, what was my last question? I don't know. I'm sorry. Was it that, do you understand that you are giving up all these rights by entering this guilty plea? Was that it?
Yes. No, I think it was no, it wasn't that one. It wasn't that you didn't get to that yet. I don't
No,
think you got
yeah,
to
you
that
didn't
yet.
ask that.
Okay. Do you understand all of these rights I have explained to you? Is that one?
Yes,
Yes, ma'am.
that is my
Okay.
Yes.
recollection.
Yes, it's that one.
Okay. Okay.
Yes.
Then my next one. Do you understand that you are giving up all these rights by entering this guilty plea to these two cases?
Yes, ma'am.
Okay. Now, has anyone forced, threatened, or promised you anything to cause you to enter this guilty plea?
No, ma'am.
Are you entering this guilty plea freely, voluntarily, knowingly, and intelligently?
Yes, ma'am.
Now, do you understand that you only have 4 years from today for the felony charges in which to file a habeas corpus petition challenging the voluntariness of your guilty pleas today?
Yes, ma'am.
And do you understand that you only have 12 months from today for the misdemeanor charges in which to file a habeas corpus petition challenging the voluntariness of your guilty pleas today?
Yes, ma'am.
Okay. Are you entering these guilty pleas because you have decided that it is what you want to do after discussing the case fully and to your satisfaction with Attorney Cole and after thinking about the case yourself?
Yes, ma'am.
Okay.
Yes.
So, Mr. Keontae, you said Tayshawn is the middle name? Okay. Mr. Keontae Tayshawn Smith, how do you plead in indictment number 24SC005002 to count 1, possession of cocaine?
Guilty.
How do you plead to count 3, possession and use of a drug-related object misdemeanor?
Guilty.
How do you plead to count 4, seatbelt violation misdemeanor?
Guilty.
Are you in fact guilty of those 3 offenses?
Yes, ma'am.
And in indictment number 26SC001861, how do you plead to the now amended charge of simple possession of controlled substance in Schedule 1 or 2?
Guilty.
And are you in fact guilty of that offense?
Yes, ma'am. Yes, ma'am.
Attorney, okay, thank you, hon. Attorney Cole, is the defense stipulating to a factual basis in each case?
We are.
And Your Honor, each case, the facts or the situation all took place in Fulton County.
Thank you, ADA Bray. Attorney
And Your
Cole?
Honor, at this time, the plea offer, I want the court to know that the state offered to the defendant, recognizing that he is eligible to plead under the conditional discharge statute. We are consolidating both cases under that statute, and our offer is 5 years probation, absolutely positively no guns, Mr. Smith, no drugs without a valid
Yes, ma'am.
prescription. Okay, there's a Fourth Amendment
Yes, ma'am.
waiver.
Yes. Yes, ma'am.
And this probation, or these 2 probations, Your Honor, are to run concurrent with each other, and they are to run concurrent to the case that he is currently on probation for, that first offender he's on probation for, 23 SC 187063.
Okay, thank you. Attorney Cole?
Yes, Judge, we are asking for you to accept the pleas on these cases as negotiated, with the 5 years probation and the cases consolidated under conditional discharge. We're also asking, since he has no felony convictions and the case is being taken under conditional discharge, if you would set a behavioral incentive date of 3 years. It's my understanding the state did not object to this in our conversation.
I do not object, Your Honor. The state does not object.
Thank you. And we are asking for you to waive probation fees and fines on these cases, so that he can just focus on getting a job and complying with his probation requirements. And then we are just seconding the recommendation that they run concurrent with each other, as well as concurrent with the case that he's currently on probation for. Mr. Smith is well aware that this offer is pretty much using his last second chance for getting out of these types of charges without a felony conviction, and is committed to moving forward and not coming back in front of our court again.
Okay, and the probationary period is 5 years on each count?
Yes, Your Honor.
Okay, just wanted to confirm. May I hear from, I'm sorry, ADA Bray, did you have something else?
No, I just wanted Mr. Keontae Smith to understand that I'm basically going out on a limb for him with regards to these two cases. And he's a young man. I'm just hoping he's gonna do better, make better decisions, and don't embarrass the rest of us who are like stepping out on a limb for you and hoping, that you get everything together and get your life right.
Yeah.
Thank you, ADA Bray. Ms. Harvey?
Yes, Your Honor. 8 cycles. He was sentenced in 2024 under first offender for possession of cocaine with intent to distribute out of Fulton County. Nothing further.
Thank you. Okay, good afternoon again, Mr. Smith. Can you hear me okay?
Sure.
Yeah, I think there's an issue with the signal, but we'll try to work through it. So 24 SC 005002, Mr. Smith, I understand you are pleading guilty to possession of cocaine. Is that right?
Yes, ma'am.
Possession and use of drug-related objects.
Yes, ma'am.
And you're also pleading guilty to a seatbelt violation in that case. Is that right?
Yes, ma'am. Yes. Yes,
All right.
ma'am.
In position number 2, 26 SC 001861. You are pleading guilty to simple possession of a controlled substance Schedule 1 or 2. Is that correct?
Yes.
Okay,
Yes.
the court. Okay, thank you. The court finds that you understand the nature of the crimes and the consequences of your guilty plea as it relates to the conditional discharge and especially the First Offender Act. I find that there is a factual and legal basis for the guilty plea, and the parties have stipulated to the facts. I have also determined that you are accepting this plea knowingly, intelligently, and voluntarily. So the court will accept the plea as recommended. Which is, well, first, these cases are going to be consolidated. They're both under the conditional discharge statute. The case ending in 5002, 5 years probation, no firearms, no drugs, and a Fourth Amendment waiver. Excuse me. In position 2, which is 26 SC 001861, 5 years probation, no firearm, no drugs, and a Fourth Amendment waiver. These cases are to run concurrently with 23 SC 187063. Both of these cases shall be concurrent. A bid period of 3 years, and the court will waive the probation fees and fines. Were there any other conditions or terms that I didn't capture on the record?
Not from the state, Your Honor.
So that,
I'm
yeah.
sorry. Count 3 and 4 or 88 break is count 3 and 4 is 12 months.
12 months probation to run concurrent to the felony probation. Yes.
I think the seatbelt violation is fine only. I don't believe it's
Okay, I don't have my red book, so how much is the fine?
I believe it's like a $10 fine, is my understanding on that case. But I can see if I can look it up real quick.
Okay, if it's fine only, Your Honor, then that one would not be 12 months probation. It would just be the payment of the fine.
All right, so on position one, so that the record was clear, on the possession of cocaine, that is 5 years probation. Possession and use of drug-related objects, that is 12 months to run concurrently, and the seatbelt violation
Would just be the
requires
amount of the
fine.
fine.
Okay.
I don't know why I'm thinking it's $40, but I don't know. Maybe
I'm trying to look.
Okay.
Yes, Ms. Moore?
Oh, sorry, Judge. I was just waiting for Attorney Cole to get the number.
Okay.
Not more than $15 is the provision.
All right, $10 fine.
Okay. All right, that will be the order of the court on the seat belt violation, a $10 fine. All right, and position two, that will be 5 years probation to run concurrently with position one and the case ending in 063. Attorney Cole, did you have something else?
And I may have missed it, Judge. I didn't know if you set the bid day on both cases and waived probation fees and fines on both cases.
I did, but so that the record's clear, the court will agree to the bid date 3 years. That's in both cases, and I will waive fees and fines in both cases as well.
Thank you, Judge.
88 Bray, if there's nothing further, I'm just going to ask you if I can sign the indictment on your behalf.
Yes, Your Honor.
Attorney Cole, may I sign the indictment on your behalf?
Yes, Judge.
Mr. Smith, may I sign the indictment on your behalf?
Yes, Your Honor.
Now, Ms. Moore, before we move to probation, was there something additional as it relates to the order?
No, ma'am, that's all. Thank
Okay.
you.
Thank you. Ms. Jolly?
Yes, I had sent Mr. Smith a chat for him to provide me with his phone number. I don't know if he got it, but Mr. Smith, could you please provide me with your phone number?
Where is it? You want to now?
Yeah, you
I
can just
see it. I
provide it.
see it.
Yeah, you can just provide
I
it
see
to
it.
me there, or if you feel comfortable saying it out loud, you can provide it to me out loud.
I just sent it to you. I don't want nobody to have my number. I sent it.
I,
Just try-
I, re- I received it. So based on that, I'm gonna, because this court proceeding is live, I don't want you to provide any personal information. I will give you a contact at the end of the court and just get some information from you to let you know when and where you are to report for probation, okay?
Yes, ma'am.
Okay, thank you.
Okay, thank you, Ms.
Thank
Jolly. Is there anything further on Mr. Smith's matter?
No, Judge.
Okay. Okay, Mr. Smith, I have accepted your plea under the terms that were negotiated by your attorney and ADA Bray, so good luck to you.
Thank you. Thank you. And Your Honor, I can have one question for the probation lady, Ms. Jolly. So I'm not sitting the same probation officer for. All right. Thank you.
They should assign it all together, though, Mr. Smith, but she'll call you, okay?
All right. All
Okay.
right.
All right, did you have any other questions,
Thank
sir?
you. No, ma'am.
All right,
No, ma'am.
okay, thank you. That concludes Mr. Smith's matter. Good luck to you, sir.
Thank you.
Okay. I believe that brings us to position 6, 25 SC 001427. Excuse me, Mr. Smith, you're excused when you can log off the Zoom. Position 6, it looks like he might be frozen again. Position 6 is 25 SC 001427. Carl Alvarez, I understand that the parties have reached an agreement on the disposition of theft by conversion felony. Is that right?
Yes, Judge. This will be a negotiated misdemeanor plea with a suspended sentence.
Okay. ADA Bray?
Yes, Your Honor. Am I not on? Hold on.
Yeah, your camera's off at this time.
Okay, I'm sorry.
That's okay.
I have to hit something. Okay, we're on.
Position 6, Mr. Alvarez.
How you doing?
Hello.
Wait a minute.
Good
Yes.
afternoon.
Good
Okay,
morning, everybody.
great. Thank you. Okay, Mr. Alvarez, you will be sworn in.
All right, Mr. Alvarez, will you raise your right hand for me, please? Do you swear or affirm that the testimony you are about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
You can put your hand down now.
Okay, and just for the record, Mr. Alvarez, we're fine with Zoom participation, but please don't move around while we're working on your matter, okay?
Oh, I'm sorry. I'm sorry.
Okay, so just find an area, and if you can stick to that for the duration, the court would appreciate it. Okay.
Mr. Alvarez, state your true, correct, and legal name for the court to also include any middle name.
Carla LeVar Alvarez Jr.
I'm sorry, what was that first name?
Carlisle LeVar Alvarez Jr.
Can you spell that for the court, please?
Carlyle.
Now, I meant the Allah Kavant or whatever
I
that
thought you
was.
said LeVar. Is your middle name LeVar?
Yes, LeVar. LAVAR.
Okay, so it's Carlisle LeVar Alvarez
Yes, Jr.
Jr. Okay, thank you. Mr. Alvarez, are you at this time taking or under the influence of any alcohol, drugs, or medication?
No.
Is there a medication that you should have taken today that you have not taken?
No.
How old are you and how far have you gone in school?
28, high school.
So you're able to read, write, and understand the English language?
Yes.
And do you understand that you were previously indicted for theft by conversion felony, but the state is agreeing to reduce that to a misdemeanor theft by conversion?
Yes.
Okay. Do you understand that you have the right to plead either guilty or not guilty to this charge? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes.
And have you reviewed the plea of guilty form with your attorney?
Yes.
Did you understand everything on the form?
Yes.
Do you have any questions about anything on the form?
No, ma'am.
Now, have you had enough time to speak with Attorney Cole about your case, including any possible defenses you might have?
Yes.
Do you need or want more time to discuss the case with your attorney before proceeding further with this guilty plea?
No.
Are you satisfied with her services?
Yes.
Counsel, do you waive formal reading of the indictment and any defects that may be in the indictment?
I do for the purposes of the plea.
And have you gone over all of your client's rights with him, and did he appear to understand them?
I have, and he did.
Now, Mr. Carlisle, wait, I'm sorry. Mr. Alvarez, you were in fact arrested on this case, correct?
Yes.
Attorney Cole and Mr. Carlisle, are either of you aware of any outstanding warrants related to this case?
I am not.
Mr. Alvarez?
No.
Okay. And Your Honor, at this time, the state is unaware of any outstanding warrants related to this case. Mr. Alvarez, I must inform you that your minimum and maximum sentence for this misdemeanor charge, your minimum is 1 day, your maximum is 12 months. Any portion of that sentencing range could be in custody, it could be on probation, or it could be a suspended sentence. Do you understand?
Yes.
Now, this is a negotiated guilty plea, which means that you, through Attorney Cole and the state, have reached an agreement on how best to resolve this case. And we are now presenting that agreement to the court for the court's approval and consideration. The court is not required to follow the agreement that we've reached, and the court can sentence you within the range we just discussed. Do you understand that?
Yes, ma'am.
And do you understand that this is a guilty plea which will be permanently recorded on your criminal history?
Yes.
And do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering this guilty plea?
Yes.
Okay. Do you understand that if you are placed on probation, you cannot violate the criminal laws or any special conditions of your sentence without being subject to having up to the balance of your sentence revoked?
Yes.
Okay, and you understand that the state is offering you 12 months suspended sentence, and it's suspended upon the condition that you have no further violation of the law.
Yes.
So if you were to violate your suspended sentence, the state could reopen the sentence, sir, and seek to revoke the balance of that suspended sentence. Do you understand that portion?
Yes.
Okay. Do you understand that if you are not a United States citizen, this guilty plea will affect your immigration status and will result in deportation?
Yes.
Do you understand that you waive or give up any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes.
All right, I'm going to go over your waiver of rights with you. All right, you have the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront the state's witnesses against you, the right to assistance of counsel hired by you, or to court-appointed counsel if you cannot afford an attorney and you request one at a trial of your case, the right to the presumption of innocence, the right to subpoena witnesses and to compel the production of evidence, the right to testify on your own behalf and to present other evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial. Do you understand all of these rights I have explained to you?
Yes.
And do you understand that you are giving up all these rights by entering this guilty plea?
Yes.
Has anyone forced, threatened, or promised you anything to cause you to enter this guilty plea?
No.
Are you entering this guilty plea freely, voluntarily, knowingly, and intelligently?
Yes.
All right. Do you understand that you have 12 months from today for this misdemeanor charge in which to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Are you entering this guilty plea because you have decided that is what you want to do after discussing the case fully with Attorney Cole and to your satisfaction with Attorney Cole and after thinking about the case yourself?
Yes.
Mr. Carlisle Alvarez, in indictment number 25SC001427, in which you are now facing a misdemeanor theft by conversion charge, how do you plead?
Guilty.
And are you in fact guilty of that offense?
Yes.
Okay. Is the state stipulating to a factual basis in this case? I'm sorry, is the defense stipulating to a factual basis in this case?
We'll stipulate.
All right, and Your Honor, all the facts occurred in Fulton County. The state's offer to the defendant through his attorney is 12 months. It was 12 months probation to be suspended upon the condition that he have no further violation of the law. It is the state's understanding that Mr. Alvarez has reached a payment agreement with Home Depot, in which he's paying restitution to them for keeping the item longer than the rental period. And that is why we are not seeking restitution in this offense. And that is why we are also not seeking probation. We're giving him a 12-month suspended sentence because he's already worked out the restitution with Home Depot.
Thank you. I understand. Anything further from the state before I move to Attorney Cole?
No, Your Honor.
Attorney Cole, I'll hear from you.
Thank you, Judge. We are asking for you to accept the plea as negotiated. As the state stated, this was a rental that was kept past the rental period. The overage cost was actually deducted from his deposit that he paid when he took out the rental. And the items have since been returned. So the Home Depot was made whole. And that is why the state agreed to come down. So we're just asking the court to accept that offer.
Okay, thank you. Ms. Harvey, is there a history that you can provide to the court?
Yes, Your Honor. 19 cycles. He was sentenced under first offender in April of this year out of Hall County for 2 counts of identity theft fraud while using or possessing identifying info concerning a person.
There's also an arrest out of Chambly from September 21st, 2024 for theft by receiving stolen property, possession of marijuana less than an ounce, possession of a Schedule 5 controlled substance, possession of a Schedule 4, and possession of a firearm or knife during the commission of a felony. There was no disposition listed for this case, Your Honor, and nothing further.
Thank you. Mr. Alvarez on position 25 SC 001427, you're pleading guilty to theft by conversion misdemeanor. Is that correct?
Yes.
Okay, and so the court finds, based on your testimony, that you understand the nature of the crimes and the consequences of your guilty plea. I find that there is a factual basis for that plea due to the stipulation. I also find there's a legal basis. I'm sorry, there's background noise.
Sorry.
One moment. Okay, do you need to move to a different location?
No, somebody else was just coming in. I'm sorry. It was a kid. I'm sorry.
Okay, no problem. I just want to make sure the record is clear.
Yes.
All right, so I will begin again. So the court finds that you understand the nature of the crime and the consequences of your guilty plea. I find that there is a factual basis based on the stipulation. I also find there's a legal basis for the guilty plea, and that you have decided to accept this plea knowingly, intelligently, and voluntarily. So the court will accept the plea along with the sentencing recommendation, which is 12 months probation suspended, conditioned on no further violations of the law. You understand that, sir?
Yes, ma'am.
Ms. Bray, I don't know if we lost Attorney Cole, do I have permission to sign the indictment
Yes, Judge.
on your behalf?
You do.
Thank you. ADA Bray, do I have permission to sign the indictment on your behalf?
Yes, Your Honor.
Mr. Alvarez, do I have permission to sign the indictment on your behalf?
Yes.
Okay. All right, that concludes your matter unless you have any other questions, sir.
No questions.
Okay. Attorney Cole, is there anything further?
No, Judge, thank you.
ADA Bray, is there anything further?
No, Your Honor.
Okay, Mr. Alvarez, I've accepted your plea and we have concluded this matter, so good luck to you, sir.
Thank you so much. Have a nice day. Thank you.
You too. Take care. We're moving forward on positions 12 and 13.
Yes, Judge.
Yes, Your Honor.
Okay, the court calls 12, which is 24 SC 003869, Amber Sean Davis has been charged with possession of a Schedule 1 controlled substance and misdemeanor obstruction of law enforcement. Position
And Your Honor,
13.
I'm sorry.
Go
On
ahead.
count 1, the state is reducing that to a misdemeanor, possession of dangerous drugs. And we are doing so because Ms. Davis has already completed a substantially long treatment program through, I believe it was Sober Living. And she's currently a participant of Motherhood Beyond Bars. And I do want the court to know that on our last court date, May 14th, she did appear in court with a substantial amount of people that are rooting for her, and they all provided letters of references and gave me documentation of all of the programs that she has completed while this case has been pending. And that is the reason why the state is reducing the felony drug charge to a misdemeanor drug charge, because she's already completed the conditions that the state would have been requesting to begin with.
Okay, thank you for that background. Ms. Davis?
She has to put on her camera.
Yes, ma'am. It would, I don't know why it wouldn't let me put on the camera, and then I couldn't hear anything you were saying, Ms. Bray.
Oh,
so
there
I
you go.
just,
Okay.
yeah, I don't know what was going on.
Okay. Are you ready to do the plea on this case?
Yes, ma'am.
Okay. Please raise your right hand for me. All right. Ms. Davis, do you swear or affirm that the testimony you are about to give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right, you
Okay.
can put your hand down now.
Before we continue,
Oh.
are you handling 12 and 13 together as part of the resolution, or do we need to address them separately?
Okay, 13 will be a null pros, and I'll put the reason. You want
Okay.
the reason on the record now, or?
Yes, please.
Okay, Your Honor, the owner of the vehicle in question is her brother. The vehicle was taken. It was for a short amount of time. It was returned to him. There was no damage, and he does not wish to prosecute his sister on this case.
Okay. Thank you for that background. You can continue. Ms. Davis, you're still under oath.
Okay. Please, Ms. Davis, please state your true, correct, and legal name for the court and include any middle name if you have one.
Amber Sean Davis.
And the spelling of Sean, please.
SHAWN.
Okay. Now, are you at this time taking or under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there a medication that you should have taken today that you have not taken?
No, ma'am.
Okay. How old are you and how far have you gone in school?
39 years old, and I got my GED.
Okay. And do you understand that you are now charged with the reduced offense of possession of a dangerous drug, misdemeanor?
Yes, ma'am. Yes, ma'am.
And misdemeanor willful obstruction of law enforcement officer?
Yes, ma'am.
Okay. Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you reviewed the plea of guilty form with your attorney?
Yes, ma'am.
And did you understand everything on the form?
Yes, ma'am.
Do you have any questions regarding anything that was on the form?
No, ma'am.
Okay. Have you had enough time to speak with your attorney, Attorney Cole, about your case, including any possible defenses you might have?
Yes, ma'am.
Do you need or want more time to discuss the case with Attorney Cole before proceeding further with this guilty plea?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment and any defects that may be in the indictment?
I do for the purposes of the plea.
Have you gone over all of your client's rights with her, and did she appear to understand them?
I have, and she did.
Okay. Miss Amber Davis, you were in fact arrested on these charges, correct?
Yes, ma'am.
And Attorney Cole and Miss Davis, are either of you aware of any outstanding warrants related to this case?
I am not.
There
I saw you
was
shake your
one.
head. Go ahead.
Okay, sorry. There was one, but then I guess it got taken off because why I ended up missing court was because I was in custody at another county. So I think that's gone. Like there's
Yes,
no
that
active
is gone.
warrant.
Okay, that is gone. You are correct. Your Honor, the
Yay.
state is unaware of any outstanding warrants as well. Now, Miss Davis, I must go over the minimum and maximum sentence for each charge. Each charge is a misdemeanor. Therefore, the minimum you could receive is 1 day. The maximum you could receive is 12 months. Any portion of that sentencing range could be on probation. It could be suspended. It could be time in custody. Do you understand?
Yes, ma'am.
And this is a negotiated guilty plea between you, which means that you, through your attorney and the state, have reached an agreement on how to best dispose of this case. And we are now presenting that agreement to the judge for the court's consideration and approval. The court is not required to follow our agreement and will sentence you within the sentencing range we just discussed. Do you understand?
Yes, ma'am.
Do you understand that this is a guilty plea which will be permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that
It's conditional discharge, Attorney Bray? Sorry.
Oh, I forgot. It is?
Yes.
Oh, yes, it is. Your Honor, we forgot to tell you that at the beginning. Okay, it is under conditional discharge. So as long as she completes what she needs to complete, then it will not be permanently on her record. So
Okay.
I forgot that part. Okay, now, do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering this guilty plea?
Yes, ma'am.
And do you understand that if you are placed on probation, you cannot violate the criminal laws or any special conditions of your sentence without being subject to having up to the balance of your sentence revoked?
Yes, ma'am.
And do you understand that you are not, wait, I'm not going to say that part. Well, yeah, that you are not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Okay. Do you understand that if you are not a United States citizen, this guilty plea will affect your immigration status and will result in deportation?
Yes, ma'am.
Now, it is my understanding that you are asking this court to treat you under the provisions of the conditional discharge statute.
Yes, ma'am.
Have you ever pleaded guilty, nolo contendere, or no contest to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
Yes, ma'am. Like what? Like you're saying, wait, are you saying have I ever
Have you ever
filed-
been convicted is what I'm asking.
oh, no. Like
Okay.
actually okay, sorry.
Okay.
Right, let's make sure the record is clear on that. Ask that question again, please.
Okay. Have you ever pleaded guilty, nolo contendere, or no contest to, or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No, ma'am.
Okay.
Can I ask you a question about this?
Well,
Is
you need
this
to speak with Attorney Cole right quick.
okay?
She took a
Sorry.
first offender plea prior.
Oh, okay. So that's the confusion.
Yes.
Yeah, that's why I was
Okay.
like, I don't. Yeah.
She
Okay.
has no felony convictions.
Okay,
Okay.
got you.
All right,
Because she
thank you for the
completed first offender.
clarification.
She completed first offender.
I believe, yes, first offender's completed, and she's never used conditional discharge.
Okay. All right. Have you ever pled guilty or been found guilty of a drug or marijuana offense in Georgia or anywhere else?
No, ma'am.
Okay. So I don't know if I need to read this part. Has your lawyer explained the conditional discharge statute to you?
Yes, ma'am.
And do you understand that if you violate the terms of your conditional discharge sentence or commit a new offense while on conditional discharge probation, your conditional discharge status could be revoked, you could be adjudicated guilty, and you could be resentenced to up to the maximum sentence for each charge to which you are pleading guilty today?
Yes, ma'am.
And do you understand that you waive or give up any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes, ma'am.
My lighting, hold on.
Thank you. I was
Okay.
just about to ask.
I know, Your Honor. I don't know what happened. So, okay. I must go over the following rights with you. You have the right to trial by jury, the right to remain silent and not incriminate yourself, the right to confront the state's witnesses against you, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney and you request one at a trial of your case, the right to the presumption of innocence, the right to subpoena witnesses and to compel the production of evidence, the right to testify on your own behalf and to present other evidence, the right to have the charges against you proved beyond a reasonable doubt, the right to appeal if convicted of these charges after a trial. Do you understand all of these rights I have explained to you?
Yes, ma'am.
And do you understand that you are giving up all these rights by entering this guilty plea?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to cause you to enter this guilty plea?
No, ma'am.
Are you entering this guilty plea freely, voluntarily, knowingly, and intelligently?
Yes, ma'am.
Do you understand that you have 12 months from today's plea in which to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Are you entering this guilty plea because you have decided that it is what you want to do after discussing the case fully and to your satisfaction with Attorney Cole and after thinking about this case yourself?
Yes, ma'am.
Okay, so under indictment number 24SC 003869, how do you plead Miss Amber Sean Davis to count 1, possession of a dangerous drug, misdemeanor.
Guilty.
And how do you plead to count 2, willful obstruction of a law enforcement officer, misdemeanor?
Guilty.
And are you in fact guilty of these 2 offenses?
Yes, ma'am.
And does the defense stipulate to a factual basis in this case?
We do stipulate to a factual basis.
Okay. And Your Honor, the facts and circumstances all took place in Fulton County. The state's offer to Miss Davis is 12 months probation, no guns.
12 months
no,
suspended.
I'm sorry, 12 months suspended. Well, it'll be probation, but it's suspended upon no further violation of the law. And the state simply asks that you accept this recommendation, Your Honor. Let me write down 12 months suspended.
So 12 months suspended on both counts
Yes, Your Honor.
to run concurrently
Yes.
and under conditional discharge.
Yes, Your Honor.
Okay. Attorney Cole, I'll hear from you.
Thank you, Judge. We are asking you to accept the plea as negotiated. And as Attorney Bray said at the beginning of the call of this case, Ms. Davis has made substantial work since the time of this arrest. She completed sober living. She works as a mentor. I believe it was not sober living, it was Oxford House, but it was a sober living program. And she completed that program. She works in that program to assist with other people who are going through it. She's been working with women behind bars. She had a lot of people in support of her at the last hearing and also had lots of letters of support. She also has a baby who I believe is about 10 months old at this time that she is raising. And we got the chance to meet her baby at the last hearing as well. And it appears that he's doing really well as well. So we are asking that the court just accept the sentence as negotiated for the 12 months suspended under conditional discharge and allow the case to seal automatically at the termination of that 12 months to allow Ms. Davis to really spend her time and efforts on continuing her progress and raising her child and doing what she's been doing for the last year.
Right, thank you, Attorney Cole. Ms. Harvey, is there a history that you can provide for Ms. Davis?
Yes, Your Honor. 26 cycles. One of those are out of the state of Florida. She was sentenced on the first offender in 2014 for burglary and theft by taking. No seal date was listed on the GCIC, Your Honor. Nothing further.
Okay, thank you. Okay, good afternoon again, Ms. Davis. On case number 24 SC 003869, do I understand that you are pleading guilty to misdemeanor possession of drug-related objects?
Yes, ma'am.
You're also pleading guilty to misdemeanor obstruction of law enforcement. Is that right?
Yes, ma'am. Yes, Your Honor.
Thank you. Based on your testimony, the court finds that you understand the nature of the charges as well as the consequences of your guilty plea. I find that there's a factual basis and a legal basis for that guilty plea. The parties have stipulated to the facts. I'm also making a finding that you are entering into this plea knowingly, intelligently, and voluntarily. As a result, the court will accept your plea and the sentencing recommendation, which is on count 1, 12 months probation suspended. On count 2, 12 months probation suspended. On both counts, no violations of the law would be the condition, and this case will be handled under the conditional discharge statute. Were there any other conditions or terms?
Not consent.
Okay. ADA Bray?
I'm here. Hold on.
Okay. Just wanted to make sure there were no other conditions or terms other than no future violations of the law.
That is correct, Your Honor.
Okay, thank you. So Ms. Davis, I am accepting your plea as presented. ADA Bray, do I have permission to sign the indictment on your behalf?
Yes, Your Honor.
Attorney Cole, do I have permission to sign the indictment on your behalf?
Yes, Your Honor.
Ms. Davis, do I have permission to sign the indictment on your behalf?
Yes, Your Honor. Thank you.
Thank you. I will do so. And I also wanted to commend you on the progress that you're making that ADA Bray and Attorney Cole described, and I hope that continues. So good luck to you and your family.
Thank you so much. God bless you. Thank y'all.
Or do you have any questions before we adjourn?
I think that's it.
Okay. All right. You take care, ma'am.
Thank y'all so much.
Understood.
Ms. Moore,
I think that's it, Judge.
Yep.
is that everything? Well, thank you all. It is 1:36. I won't see y'all the rest of this week, so I'm gonna go ahead and tell y'all have a good weekend. Thank you, Miss Harvey.